Thank you, Mr. Chairman. Thanks to you for holding this very important hearing, and thanks to the witnesses for being here today. And I associate myself with basically everything that's been said here today. It's been remarkably agreeable, which is really pleasant and surprising. So I hope that we can work together to try to bring clarity and rectification of these problems. So here's my first question goes to Ms. Burton. This is for you. You said in your written report, because information's in a cloud storage bin rather than a file cabinet, and this is, by the way, this was iterated by every witness. The government should have no greater investigative and secrecy interest due to the case of due to the ease of access. So I guess my question is, if you were the DOJ or government, how would you respond to that? Because I mean, that's the blanket statement, is that there is no greater, just because it's easier to claim secrecy, there's no greater cost. How would you respond if you were DOJ to that?
I mean, if I were the Attorney General, and I think he's headed in this direction, I would want to be responsible as a citizen of the country to balance all rights and all needs. And that's why we have judges. That's why we have notice. That's why we should not be putting our cloud providers effectively above the Constitution. As you say, Microsoft makes some efforts in this regard, but that is not universally the issue. And I would tell you there's a lot of things we don't know right now. And if I'm the DOJ, I don't want to be convicting people or bringing cases where I can't defend in full measure the evidence that I put before a court and give someone the right to challenge that. I think that's just, playing, should we say, pro ball in a bad way.
Well, I don't disagree, but I haven't heard basically from any of the witnesses, nor have we seen in practice over years, that DOJ really is concerned with being a pristinely good due process adherent and protecting the rights of everybody. I mean, you've all iterated examples where they've abused this authority, and Mr. Burt, this is coming into your shop 3,500 times a year, and so we're led to believe that this could be many thousands of times. So you've given your set of prescriptions as well, but why do you think it should be? I mean, in a physical warrant, with physical materials being seized, it's 30-day. If it's going to be secret, it's 30-day per statute. Why do you think it should be 90-day for data?
That's a very good question, and any reasonable time is acceptable to us, and I think to the technology industry. What we're trying to do is rein in what we have seen, which are indefinite secrecy orders that have no termination date. What we've seen since the DOJ formulated its policy in response to litigation that we filed back in 2017, we've actually seen somewhat of a decrease in those indefinite orders, but we still get hundreds of those every year. The standard that we see typically is a year, and that's just far too long a time period, even when it's actually justified to have a secrecy order. So our response would be, there's a very small universe of truly justified secrecy orders. Where those secrecy orders are truly justified, then as long as 90 days might actually be acceptable.
So I just have about a minute left, and I would like each of you to respond to this, because each of you have talked about, one way or another, reliance on the courts as arbiters here, and yet they seem to be just rubber stamping boilerplate language. I am concerned about what I view as a necessary stick approach to DOJ for their abuse. What is an appropriate punitive measure? I mean, if in a regular criminal case with physical evidence, you're going to have the exclusionary issues that will come in if there's fruit of the poisonous tree, et cetera. What happens here? What is the punitive measure that devolves to bad actors? DOJ, Professor Turley, we'll go with you, and then right down the table, and then.
Well, I certainly agree with your point that the courts have not exactly covered themselves in glory, and part of the problem here is that these judges are getting thousands of these things, and they don't want to go into the weeds on some of these issues. And so you have cases like In re grand jury out of the ED New York that are saying, look, this is just boilerplate. We're just getting boilerplate over and over again, and that's not saying anything. You're going to have to structure what a court has to find and what a court must establish in writing if we're going to be able to do anything. And I think you have to establish standing and an appellate procedure with adversarial process. Those are the things that will result in a change.
Gentleman's time has expired.
Okay, well, thank you very much, and I yield to Mr. Biggs.
I thank the gentlelady for yielding, and when we left off, when I ran out of time, Professor Turley just answered my question. I'll just remind you of what it is and give you the context. I was asking about the stick that might be necessary to help what we typically think of as an independent court. So you all seem to be in agreement with guidelines, et cetera, and statutory guidelines. How do you make sure that those are going to be tough enough?
If I may, I think...
Yeah, so Mr. Burton, then down the line, then Ms. Burton.
If I may, I think the concept of extending the Fourth Amendment to data that's stored in the cloud is a reasonable framework to consider here, because then that would take all of the existing sticks, as you put it, that would apply when government overreaches and violates Fourth Amendment rights, exclusion of evidence and so forth, and it would be applicable here as well. The irony is that Fourth Amendment jurisprudence is based on this notion of reasonable expectation of privacy. And in fact, your security and privacy of your data is higher in the cloud than it would be if you kept it in your premises or on your network at your corporation. So the technology is not, the law has not advanced with the technology to protect our citizens and our organizations' information.
Thank you.
And just to add to what my colleague here said, one of the reasons that media organizations are putting their data in the cloud is because they are also concerned about the security, and that they can't afford to have the kind of technologists and technologists in their shops who could protect from hacking and phishing and all of the other problems that we have with our data. So it puts them it puts many of the media companies in a really tricky position. But to the point about what kind of penalties you could have, there is the possibility perhaps of a 1983 action if rights were violated, and journalists have used that successfully in certain cases.
And Ms. Burton, before you answer this, I think we all would presume, at least I do anyway, that there's a private property interest. You have a private property right in your data, right? And thus it gets back, and it begs the question that Mr. McClintock and Ms. Sparks were raising, and actually Ms. Lofgren. Why then do we have these loopholes, and then Professor Turley expounded on it, why then do we have these loopholes that attack Fourth Amendment rights over your otherwise well-known and it should be established private property interest in your data?
Time has expired. The witness may answer the question.
If it's to me, the answer...
Ms. Burton.
Ms. Burton, I'm sorry.
I think that the minute we get enough process into a statute, that you're going to see prosecutors act more rationally. And I would leave it to the courts to suppress the evidence and to dismiss cases. I think that, from a prosecutor's point of view, is remedy enough. I'm not in favor of creating lots more causes of action around this. I think we're trying to simplify it. I think we're trying to protect rights. And I think the courts would actually make sure that that occurred.
Gentleman yields back.